दिसला मॅडम? अनम्यूट करा, अनम्यूट करा.
ऐकू येते?
हा, थोडं जरा जोरात बोला.
का बरं? आता
नाही, तुमचा आवाज कमी येतोय.
आता येतोय?
हा, येतोय येतोय. हा, येतोय.
स्पीकर मोठा
थोडा
केला ना?
इकडच्या साईडला सारखा, डावीकडे.
काय काय?
डावीकडे सारखा. हा, बरं. हा,
ऐक ना.
हा, बोला ना.
आदित्यने ऐक ना, बरं झाला. इथं हे करायला आपल्याला मागे काहीतरी दाखवायला काय करता येईल का? झूम मीटिंग चांगलं दिसतंय? बरं,
चांगलं आहे, चांगलं आहे, काही प्रॉब्लेम नाही आहे. बॅकग्राऊंड चेंज करता येईल तुम्हाला?
कसं करता येईल तेच तर सांग ना.
मनोज करे त्यांची बॅकग्राऊंड बघ बदलते ते कधी छान दिसते.
करता येईल का? मोड मध्ये जायचं, सेटिंग्स मध्ये जायचं. बरोबर आहे? नको हे आपलंच राहू दे. नाही चांगलं दिसतं. बरोबर आहे, जे आहे तेच बरोबर. हो, कार्यक्रम कधी संपला? तू गेला होता का? नाही गेलो. थँक्यू. शुभम सर कितने बजे स्टार्ट करना है?
मैम at 4:30, 4:30 in
ठीक
just
है,
10 minutes.
ओके ओके ओके। पर अब तक स्टूडेंट ज्वाइन नहीं हुए हैं।
Can you speak something and we have to check your voice whether it's coming or not?
Hello, am I audible?
How you're so audible.
रोहित सर, शुभम सर, हेलो।
Can you switch off your camera as of now?
हाँ बोलो.
Am I audible?
Hello everyone, we'll be starting in 2 minutes. So, ma'am, shall we start with the session?
शुभम सा
जी मैम, yes ma'am.
फोन उठाओ ना, मैं आपको फोन कर रही हूँ, म्यूट कर.
Oh, hello ma'am. Ma'am, can you start with the session?
Yes, guest has joined with us.
Yes ma'am. Sorry sir.
Okay, no problem.
Yes
We
ma'am.
can start.
Okay ma'am, thank you.
Yeah.
Sorry sir.
A very good evening.
Yes. So sir, thank you sir for the for joining the session. So we'll start with the session. Yes.
Thank you for having me here. Very pleasant evening to one and all present here.
Good afternoon, sir.
Very,
Yes.
very good afternoon. And
Sir,
namaskar to ma'am.
नमस्कार सर, नमस्कार.
Rajwala ma'am, namaste.
sir, session will you sir just greet the sir and ma'am, and then we'll start with the session
Sure,
with
sir.
the speech of ma'am. Yes.
सर्वे भवन्तु सुखिनः सर्वे सन्तु निराम्यः सर्वे भद्राणि पश्यन्तु मा कश्चित् दुःख भाग् भवेत्. Meaning, may all be happy, may all be free from illness, may all see what is good and auspicious, and may no one suffer in life. On behalf of New Law College Bharati Vidyapeeth Pune, it gives me immense pleasure to welcome you all to Saamanjasya, the arbitration skill and capacity building program. We are fortunate to be guided by the vision and encouragement of our Dean and Principal, Dr. Ujwala Bindale ma'am, our Vice Principal, Dr. Jyoti Dharam ma'am, and our IQAC Coordinator, Dr. Vidya Dere ma'am. We are equally grateful to our respected professors, Dr. Advocate Rohit Survase sir, and Mr. Shubham Tripathi sir, whose dedication has made this program possible. Now, I would like to invite our Vice Principal, Dr. Jyoti Dharam ma'am, to inaugurate the session.
Thank you, Ansh. Good afternoon, everyone. It's my pleasure to be part of this program. I'm here formally introduce you about Bharati Vidyapeeth and our new law college. So Bharati Vidyapeeth, deemed to be university, it was established on 10th May 1964 by the visionary Honorable Dr. Patanrao Kadam Sahib. Bharati Vidyapeeth was founded with the noble objective of fostering intellectual awakening and the overall development of our nation through education. So I like to inform you that Bharati Vidyapeeth deemed to be university has been recently accredited with A++ grade by NAC in 2024, which is the highest recognition of academic excellence, quality education, and institutional performance. The legacy of this university is built upon the guidance and support of our esteemed patrons, Professor Dr. Shivajirao Kadam, Chancellor, Dr. Vishwajit Kadam, Secretary and Pro Vice Chancellor, Professor Dr. Vivek Shauji, Vice Chancellor, and Professor Dr. Asmita Jagtap, Executive Director. Their unwavering dedication has propelled New Law College to achieve new heights in legal education and research. New Law College was founded in 1978 and was inaugurated by Honorable Mr. Justice Y.B. Chandrachud, the then Chief Justice of India. New Law College recognized for its international excellence and legal education. The institution has been ranked among the top law schools in the country. Today, we are here to inaugurate Saamanjasya, a skill and capacity building program. This course aimed to nurture legal intellect and practical expertise in alternative dispute resolution system. This course presents a dynamic platform for participants to engage in rigorous discussion and hands-on learning in arbitration and conciliation. This intensive 7 day course presented is designed to equip aspiring legal professionals with the essential skills and knowledge to excel in dispute resolution. I declare the certificate course open and wish you all success ahead. Thank you.
Thank you so much, ma'am. A warm welcome to Prastavna, the first day of Saamanjasya, the arbitration skill and capacity building program. Today we gather not just to begin a session, but to begin a journey. The word Prastavna in itself means an introduction, a beginning, and this marks the start of a meaningful dialogue on arbitration, justice, and balance. It is our honor to welcome our chief guest, Advocate Shaurya Krishna Sir, whose distinguished practice before the Supreme Court and NCLAT brings invaluable experience and wisdom. We look forward to his insights, which will guide us in understanding arbitration, not just as a rigid mechanism, but as a living, evolving practice of law. Thank you.
A very pleasant and good evening to everyone present here. Good evening, Vice Principal, ma'am. Good evening, Dr. Rohit, student coordinators, all the students and fellow mates who have joined this seminar. I hope I am audible.
Yes, sir.
Yes, sir.
Yes.
First of all, I would like to extend my thanks to Dr. Rohit for inviting me here to this prestigious webinar that we are having and a certificate course program on arbitration. And I'm really glad by reading the name of this entire program. It's called Saamanjasya, which very well do justice with the topic on which we are going to speak and discuss today. Samanjasya is a balance, it's a harmony, it's an agreement that we often lose in courts, arguments, and litigations, long pending litigations. Hence, we come to a different mechanism, an alternative dispute resolution technique, and that's arbitration. Arbitration, as you all know, that it's a alternative dispute resolution. I'm not going to say something extraordinary about it. But I must remind you that arbitration is not something that is the act may be new, but the concept of arbitration is not very novice. It's very ancient, in fact, especially with context to the Indian civilization that we have. Since ancient times, we used to have panchayat that used to happen in villages when cities and towns were not so developed, when the globalization was not there, and in fact, nationalization was not even there. There used to exist panchayats. I'm not talking about the panchayat that we see on OTT platforms, but I'm talking about the real panchayati Raj system that is existent in our country since long. And needless to say, the alternative dispute resolution that Sri Krishna used to take when he went to prevent the Mahabharata. So the Panchayati Raj system, when it used to happen, the award that was decided, that the decision that was taken by the noble members of the villages, that used to be final. And when British came, a new system of codified laws came into existence. And when codified laws came into existence, courts became a part of our daily lives. And when court became the part of our daily lives, there comes a lot of litigation in the courts. And it has become a very common phenomena to say that I'll see you in court, be it before pre-colonial era or be it post-colonial era. The courts were always loaded, not as much as now they are, but they were always full and occupied. The Panchayati Raj system is not just a system that was introduced by the Indians or the noble people or the villagers of that time. It was rather recognized in a very important case, and that's Vidya Sitanna versus Mariwada Viranna. That's AIR 1934, PC 105, where the Panchayati Raj system was first recognized by the Privy Council in the pre-independence era. Now, the concept of arbitration is very wide. It is not saturated up to a particular level of dispute. I will come to that later when we'll discuss the myths and the realities versus the realities of the arbitration. But the process and the scope of arbitration is very wide. First of all, it is not bound by any national policy. Rather, arbitration is a mechanism that has been adopted globally. And although, coming to the historical background of arbitration, although US and UK were pioneers in the use of arbitration, the first international conference of American states in 1890 for systematic arbitration was developed in the year 1890, but it was not accepted. Then the Hague Peace Conference took place, where it was majoritarily accepted by the world powers in 1899. Then came the major key player in the arbitration, that is the New York Convention. That took place in 1958. And New York Convention also takes part in our Arbitration and Conciliation Act 1996. The jurisdiction, the seat, and the enforceability is based of the agreements and of the arbitration that takes place under the umbrella of New York Convention 1958 finds its seat in our International and Conciliation Act 1996. Then the Indian Arbitration and Conciliation Act came after all these international conferences and on international conventions in which India was a part of, and UN Citral Model Law on International Commercial Arbitration 1985 prompted member nations of the United Nations to amend and legislate laws to bring uniformity on international arbitration and execution of international awards. And hence, Indian statute came. Now, coming to the comparison of arbitration with litigation, its time, its cost, and efficiency. Now, most of the people think that arbitration, since since the amendments, the arbitration has become quite saturated. It has become quite time bound, but often it depends upon the cooperation of the parties and efficiency of the arbitral tribunal to decide something or to come to its conclusion. Now, comparing it with litigation, of course, it saves time. Suppose there is a dispute between international companies, foreign companies, and prior to the globalization or even after to the globalization, many foreign companies did not dare to come to Indian market because of the what happens if any dispute occurs. Because the image of our Indian courts with respect to the pendency, with respect to the disposal of litigation of the pending matters is quite not good, not so good. So suppose a litigation that or a civil suit that decides, say, in 10 years or 20 years, we can decide that very particular aspect within a year or few days or few more months. So when we compare litigation with arbitration, definitely arbitration is far more fast paced than litigation. It often weed out different kind of other procedure that happens in litigation. And regarding the time, it becomes a boon for everyone in the international market. But if you talk about the cost, it entirely depends upon the parties that agreed and that the parties that came into agreement. I remember I used to assist an arbitrator in a very one of a very high profile arbitrations that used to take place. It is decided now, which used to take place in Delhi. It was between a very major real estate developer and Yamuna Development Authority. So I used to remember that a lot of senior advocates used to come to that arbitration. And both parties used to pay a hell lot of money to the arbitrators as well. While when you go to the Indian courts, you don't need to pay to the to organize a system, to organize the courts. It is very it is very well taken care of by the courts and by the government itself. So when you talk about the cost aspect of arbitration, it becomes entirely a different story. Like why many people can't afford arbitration. I'm using the word afford. I'm not using the word choose here. Because sometimes arbitration, maybe it is your choice, but certain circumstances are there that you cannot afford arbitration. Now it comes to the efficiency. Mostly you see in international arbitrations, very sound retired judges or an adept advocate or a lawyer or a specialist in that field becomes the arbitrator. It will be very wrong of me to say that the arbitral awards that are subsequently delivered are not efficient. But again, it lacks the basic merit. And it is entirely my personal opinion. Why I'm saying that is that because even in the Arbitration and Conciliation Act, there is Section 34. And I find it a little lacuna in this entire genesis of arbitration that an award is being passed by an arbitrator whose competency and whose qualification, maybe he could be a retired High Court judge, maybe he could be a retired Supreme Court judge or a renowned lawyer. The judgment, the award has to go through a very thin line of analysis by the Indian courts itself. And that Section 34 is included in our statute in the Arbitration and Conciliation Act 1996. because of this efficiency factor. And this is the beauty of our constitution, of our statute, that no statute, no authority, be it courts or be it arbitration, can be left free. They have to hold some accountability, they have to hold some truthfulness, and they have to be efficient. It is the arbitral the tribunals has nothing to lose once their efficiency is thwarted, or whether when their efficiency is challenged or being criticized by the Indian courts. But subsequently, the arbitral tribunal or the arbitrators, they have to be accountable so that their accountability may fetch further arbitrations. So I'm not glorifying arbitration, but I am also not criticizing it in a way that it is not a solution at all. Because there are some things on which we can work upon and make it a better platform. Now, coming to the types of arbitrations. Now, there are three types of arbitrations there are written, which are written very wisely, depending upon different kind of arbitrations that we have. It's the institutional versus ad hoc arbitration, which is based on the approach of how you are going to tackle it. And it is again between the parties. Second is the domestic versus international arbitration, which is a factual aspect. You cannot go away. You cannot avoid this. If you are domestically, if you are two nationals of a same nation, two companies of the same nation, you have to go for the domestic arbitration. Otherwise, you have to opt for the international, and then you have to uh, go through different institutional arbitration centers and adjudicate accordingly. And then there is ODR, my favorite subject, and which is very futuristic. Now, coming to the institutional and ad hoc arbitration, I think it has become a monologue as of now. So, can anyone from the participants tell me what is the difference between institutional arbitration and ad hoc arbitration? Anyone from the participants? I repeat, in fact, is there anyone from the participants who can tell me the difference between institutional arbitration and ad hoc arbitration? You may not need, you need not to switch on your camera. You can speak. Otherwise, Ansh has to take charge.
For sure, sir. I'll help them out.
Please
Sir,
do that.
as far as my
Yes.
understanding is, institutional arbitrators are one where the parties agree to arbitrate using rules provided by an arbitral institution, which exercises some control over the proceedings as well. And in contrast, it is like ad hoc arbitration is that where an arbitrator is appointed by the parties. He took the charge. He takes the charge for that.
Correct. So there are many institutional arbitration. Institutional arbitration are something. There are many institutions that are responsible for the smooth functioning of any arbitration. Suppose in litigation we have a court system. In litigation we have a court. We have a registry. We have our clerks, and we have a procedure laid down by that court. Suppose you want to file something in high court rules, so the high court. So there are high court rules under which the format of the any application or any petition is given. Suppose in Supreme Court you want to file something, then there are Supreme Court rules 2013, under which whatever you want to file before the honorable court, The format of that petition or application is there. The procedure in which you can file that, the procedure is also written. How much stamp duty you have to pay is also written in our act. But when you go for an arbitration, these factors are missing. So to meet out these factors for a smooth functioning of any arbitration, this institutional arbitration institutions are there. So institutional arbitration is administered by arbitration institutions which provide rules, which provide arbitrators, which provide infrastructure. So that's the most important point that I forgot to mention. That in a proper in a old-fashioned litigation, you have courts, you have an infrastructure, but in arbitration you lack them. So that is the major factor why people prefer, though they are sometimes they are expensive or they take a little commission out of your arbitral award, but all these requirements get fulfilled. The exceptional examples of institutional arbitration institutions are the SIAC, the Singapore International Arbitration Center, and then Hong Kong International Arbitration Center. We have DIAC in Delhi. We have MCIA in Mumbai. So these are the institutions which clear rules, which have credibility, and to an extent have a global recognition as well. The only negative point that I find about these institutional arbitration institutions is that they are expensive. And sometimes they cannot meet up and they cannot accessible to small companies or to small disputes. So this is a very approach based arbitration, and it entirely depends upon the parties that that are into an agreement. And again, it becomes very important when you draft any agreement or any memorandum of understanding. It becomes very vital, it becomes very important how you draft that dispute resolution paragraph. And often that dispute resolution paragraph or that dispute resolution point is annexed with an appendix, and that appendix is the arbitration agreement. Time and again, the Honorable Supreme Court and different courts of India have explained the importance of an arbitration agreement. And that arbitration agreement is something that decides your approach towards the arbitration if any dispute arises. So that's the basic difference between institutional and ad hoc arbitration system. Ad hoc is the general approach, like two companies come into an agreement, and if any dispute arises and they have this dispute resolution through arbitration column in their agreement, they may go for it. So so far that we have come, like, do you have any doubt regarding this aspect? You are free to ask, or we may come to the question and answer chapter later. Now coming to the domestic versus international arbitration. Now in domestic, as it says that all parties are from the same nation, are Indians, may be seated internationally abroad, but both parties are individual and both parties belong to the same country and are entirely governed by Indian laws. It's a factual approach, like whatever the situations are, whatever the companies are, you may again go for it, for the domestic or for the international arbitration. Now coming to the ODR, which is why my personal favorite is because I am personally associated with this and I am consulting one company which is working in ODR. So ODI is online dispute resolution, and there are certain forums and certain websites that are involved in providing online dispute resolution. Now, online dispute resolution comes from the concept of mobile courts. Like sometimes you have right now that what happens is that we have to step out, we have to go and approach the courts to get the justice. While in ODR, what's going to happen is that the courts will approach you to get you the justice. The online dispute resolution is quite futuristic and it is still developing. Well, even the arbitration is developing itself, but the ODR in one aspect is developing. Now, there are certain technologies that are coming into the light that develops your digital avatar. Now, what your digital avatar is going to do? Your digital avatar is sitting here. Your digital avatar, if you are not there, then it is sitting somewhere else. It's the same body, it's the same voice, it's the same intellect, and it is deciding many things. But as of now, it's a very far-fetched approach. And this ODR concept is very personally favorite because I was also involved with one company. It's called peopleclaim.com. It's a US based ODR startup and it has become tremendously successful. So ODR is one of the methods that will save time, that will save a lot of fuel and will often will also give equal level of efficiency. But I'm not sure that how the evidence is going to be appreciated and how the hearings are going to take place if any fraud comes into picture, if any impersonification comes into picture. Then how are we going to tackle it? It is still a big question. Now coming to why arbitration, understanding its power and potential. Now arbitration, as I already said, is not something which is new to this country. The arbitration and other mechanisms like mediation, negotiation was always there in our Indian system. And through Saamanjasya, I may say, we may very well adjudicate our own differences, our own disputes. Coming to the power and potential of arbitration, how powerful this arbitration is. So, any arbitration award, especially the international one, how are you going to enforce it in our country or in any country? I'm telling you the power. Arbitration is very powerful because it is governed by the UN Central Model of Law on International Commercial Arbitration. It is backed by New York Convention 1958. And when I say these conventions, these model, I'm also talking about the countries which are part of these models, the countries which have signed the treaties. Even if you try to escape the enforcement, you cannot escape the enforcement agencies of these countries, the countries which are part to these conventions and these conferences, and they have signed a treaty. Suppose if an international arbitration takes place and government in fact loses its claim and refuses to enforce the arbitral award, then that arbitral award can be treated as a decree of the court by the Indian courts itself. So that's such power that an arbitral tribunal enjoys. And that's the beauty of it, that the Indian courts are not adjudicating the dispute, but it is converting the award of that dispute into its own decree. So that's the power and the potential to which any arbitration or any arbitral award can go. And there is no possibility of escape at all. Now, I have pointed out certain myths and realities as well, and I would like to debunk that. Now, myth number one, arbitration is always faster than court litigation. Sometimes it is. But while arbitration is designed to be swift, delays occur, especially in cross border dispute or global crisis. Parties often replicate the litigation style. Sometimes it becomes voluminous, there are voluminous pleadings, there are lengthy cross examinations, and sometimes there are some appeals or the disputes that are already decided by the court. They often convert into an arbitration. Now, this is a very common phenomena that we are seeing in day-to-day arbitration. I may say that these are the common challenges that we face. And the true speed of any arbitration depends upon the cooperation of parties and the efficiency of the arbitral tribunal. There are strict timelines post 2015 amendments, but still, we cannot negate the part that there are lengthy, voluminous pleadings, there are voluminous documents that needs to be go through, and sometimes the cross examinations often take time. Just for the sake of the deadline, just for the sake of the timeline, we cannot compromise with the merit of the case. Otherwise, it would be a grave derailment of justice. So sometimes it takes time, and I believe that taking time is for good. But as an arbitrator, we have to be efficient at the same time. Now, myth number two, that arbitration is always cheaper. Now, the reality is arbitration can sometimes be more expensive than court litigation. Arbitrator fees, institutional cost, cost of the venue, cost of the expenses for expert witnesses, they often add up. For small and medium enterprises, these all factors become burdensome. But however, if compared to you know, ever-ending, ever-going litigation, it becomes sometimes expensive. Myth number three. Now, arbitrators are biased or favor powerful corporations. Now, many people avoid coming to the arbitration, opting arbitration because of this particular factor. While the reality is that arbitrators are bound by strict codes of independence and impartiality. Before the commencement of any arbitration in India, the arbitrator has to give on oath that he is impartial and he is absolutely independent. And he has no links or relations to the parties that are contesting the arbitration. The most reputable institutions have disclosure requirements as well. And there are mechanisms to challenge the biasness of the arbitrators as well. And moreover, in arbitration, since it's quite independent, both parties can choose their own ways. So parties themselves have a say in selecting the tribunal or selecting the arbitrator. While perceptions of bias exist, the reality is that arbitration provides more neutrality than being dragged into the party's home court or national court. I'm talking about the international arbitrations, especially. Now, myth number four, that arbitration lacks enforceability. Now, as I have already discussed the New York Convention, I've also already discussed the UN Citral model law on which the Arbitration and Conciliation Act 1996 is based. So we may say that the global enforceability is far strong than most of the court judgments, which often face hurdles under local laws. So you have no hurdle when any international agreement is an international arbitral award is passed. I'm not saying that any hurdle, but in comparison to the challenges that we have in Indian courts, and then we have appeals, and then second appeals, and then so on and so forth. The arbitral awards, especially the international one, do not have to go through multiple litigations if challenged. Now, myth number five, that arbitration means no role of courts. But the reality is, arbitration is not a complete replacement of courts. Rather, it is a partnership with courts to decrease the burden that is imposed upon our courts, especially at the very base level. Any arbitral award, now there is a provision of challenging it, there is a provision of setting it aside. So we cannot say that courts have no role to play in an arbitration. Now, myth number six, that arbitration is only for big companies or foreign investors, while the reality is arbitration is equally useful for domestic disputes, small businesses, joint ventures that often come across. And I believe that these online dispute resolution is going to make it more efficient and easier. I myself, I'm telling you that I am doing certain arbitrations by sitting in this very room. Now, the courts are also virtual, I admit that. But arbitrations are more flexible. So it is not like that only big companies and foreign investors are doing arbitrations, and it is meant for those big giants only. But it is equally efficient, sometimes cost effective as well, for the domestic companies and medium sized or small sized enterprises as well. Now, myth number seven, that arbitration lacks accountability and transparency. The reality is, in commercial arbitration, confidentiality is actually a feature and it is not a flaw. In any commercial arbitration, now there are companies that the arbitrations happen over technologies. Like like X company is building a software and Y company is the developer, app developer. So the technology of Y is being X is being displayed by Y, and due to some payment gateway issues or due to some some or the other issues, the matter goes into the arbitration. The arbitral tribunal is supposed to be confidential. Now, those information, if they come in court, for an example, it becomes a public document. But in arbitration, this is a plus point for, especially for the uh, tech-based companies or biotechnology companies who are working tirelessly and endlessly in inventions, in patents, in a very confidential manner. So arbitration is the only way for them to resolve their disputes. So confidentiality is actually a feature; it's not a flaw. So these are the myths that are mostly people have that in their mind that I have addressed so far. And now coming to the last set and the last theme that I have given is the global rise of arbitration in commercial and investment disputes. Now we have already discussed the evolution of arbitration in national as well as in international sphere. Let us talk about the commercial aspect and the investment disputes that happens. Whenever any dispute happens between two parties, especially at a global level or a cross-border dispute, there has to have an arbitration agreement. Now, how that arbitration agreement is signed and filed, it entirely depends upon the convention under which that arbitration agreement comes into and the countries that are a party that particular convention. And it is not only the convention that is the only thing that we have to see, but it also the bilateral treaties, investment treaties, BITs that happens between the countries. Since there is a trend of globalization, since there are markets open now, so the companies are setting up their offices cross border countries, and every business wants to have a global presence. And if they want to have a global presence with this ever rising culture of globalization and privatization, there has to have disputes. If a company based in Noida wants to set up its office, say in Denmark, say in Florida, there has to be disputes. And those particular disputes are rising because the companies are getting more and more involved in their expansion now. And the world market has become narrower because of the technology. Like we are conducting this seminar so effortlessly, so they can also conduct their business so effortlessly. But businesses involve transactions, and transactions, whenever there are transactions, there has to be dispute. And this is the gift of globalization, that arbitration is rising at a global level. Well, to sum up, I think I have covered almost everything in my lecture. I believe arbitration is a way forward and a much more synchronized way of resolving any dispute. But there are many things that need to be taken into consideration. We we should not glorify arbitration completely. We must also look into the shortcomings and work as cooperatively and as in togetherness as possible. So, if you have any question, you may please ask it.
Yes, any participants are having any question, you can raise your hand.
So we'll just call out, or you can directly on your cameras and speak. Yes, Raj. You can on your camera and speak. Yes, Raj.
Raj, you can put up your question.
I think someone has asked a very interesting question. Can we say that arbitrations are private courts?
Can you hear me? Hello.
Yes, I can hear you, sir.
Yeah, this is Raj. Hi. Hello, sir.
Hello,
How are
hello,
you doing
hi.
today?
Great.
Yeah, it was a great lecture. Thank you so much.
Yeah, most welcome.
Sir, I was just wondering, how do we inspire confidence in people to go to these arbitration courts, and what are the major measures that are in place, um, so that we can get more people
I think
to
we are
come?
already on the way, and organizing such seminars, organizing such programs is a first step towards inspiring people towards arbitration. And I believe
Yeah,
that as
inspiring confidence in the process, and
yes, yes, yes,
yeah.
exactly.
So
So there are resource people, and I think after me there are 5 or 6 other resource persons who are going to speak. So I have already spoken about a brief background about arbitration. I have given it a little push and a little start, and I firmly believe that the next resource persons are going to do full justice with whatever I have said so far. And I believe that organizing such academic programs, organizing awareness programs, in fact, is definitely going to help us out. And I believe that it's a very small suggestion, and I would definitely love to place it someday somewhere, that the arbitration institutions that are there globally and in our country as well, so they often organize such programs, and even I get some links and some of their registration forms on my email, but it is only for the people who are involved in this arbitration and all, for the arbitrators and for the lawyers and for the stakeholders. But we must also reach out to the general public as well who are doing business. So there are many matters that approach the courts and the commercial courts of India, that they directly come to them. They don't go for arbitration or something like that, because there are certain myths about arbitration that needs to be broken. So I believe that awareness is the first and foremost and the most important step that should be taken in that, to inspire confidence in people regarding the arbitration. Is there anyone else who would like to ask any question? I would love to interact if someone want to.
Sir, Kapil in the chat group has asked, can we say arbitration on private courts?
No, we cannot say that. though, though, in a very saturated way, we can say that it's a very privatized way of resolving a dispute. But court has a very different meaning, and I believe that we should not interfere with the definition of court while making it public or private. So it's a private arrangement. It's a private Saamanjasya between two parties to resolve any dispute.
So I have a question.
Yeah, please
Like
ask.
you said that you discussed about the myths, which said arbitrations lacks in possibility. It is a myth, but over the year we have seen that there are certain
Mm.
cases which took place, like an international foreign award is refused in India.
Mm.
In the Renu Sagar Power Company Limited versus General Electric,
Mm.
1994, and as well
Mm.
as NAFED versus Ailment SA,
Mm.
which was a very latest case in 2020.
Mm.
So they all discussed a single word which said that the policies, public policy, not
Impacted.
were very much impacted about if they are allowing the award. So, how are we looking after that? For example, as you said that we have signed in the last segment, which you discussed about the globalization, that we have signed many pacts as well as treaties. So, we do sign that ना अपने
Mm,
policies को देख करके.
mm,
So,
mm.
how it is lacking यहाँ पे? मतलब arbitration कैसे lack नहीं कर रहा है enforceability?
I think most important aspect and most important role in such kind of disputes is the responsibility and accountability of arbitration institutions. Whenever any arbitration starts, you already know the dispute, and you already know that there are if a certain award comes, if it falls into that direction, it affects the policy of the country. So this aspect has to be dealt before having this arbitration, before conducting or commencing the arbitration. So this was the no, look, no system is perfect. Even arbitration has a lot of flaws, and enforceability. It is not enforceability part of arbitration is not absolute. So the checks and balances have to be addressed before commencing the arbitration, and I believe that it's the duty and responsibility of the arbitral tribunal in general. It is not the fault of the process. It's the fault of what do you say, a cross check that has to be there.
Thank you, sir.
Most welcome, Ansh.
Sir, there is one more question by Supradeep Patil in the chat box, that what is the difference between arbitration and conciliation?
Now, arbitration and conciliation. Arbitration has to be begun with an agreement, first of all. Conciliation does not exactly have to be the agreement part of it. Conciliation can be done in a more, not in such a mechanical manner. It does not give any particular rules and set of procedure that has to be followed. While on the other hand, arbitration needs to have a proper uh, cross check, and there has to be certain conditions that needs to be fulfilled in order to have arbitration. A conciliation is very common in many of the tribunals, in fact, wherein the dispute could be resolved at a preliminary stage, but still the complainant goes to the certain tribunal, and sometimes that tribunal or that quasi judicial body have this specific room for the conciliation as well. So arbitration is pre-decided, and conciliation can be decided at a later stage, you may say.
Okay, sir. One Manju student is there who
Hmm.
can't access due to some technical error. So she has WhatsApped me the question. Her question is, if arbitration clause is missing, then can we not refer to it in arbitration? As sir has said that international dispute resolution, if two countries, if there is a treaty, then only the matters can be done.
It again depends upon the arbitration institution. For example, if you do not have a treaty, if you go to an arbitration institution itself can set up rules. The arbitration institution enjoys such powers that it can frame your rules, it can frame your procedure, it can frame your own codes of arbitration, and especially the enforceability part. And even if two countries are not into a symphony of an agreement or treaty, those codes and those rules, those procedures are uh, going to prevail. And when you sign that, that becomes your agreement with, it becomes a tripartite agreement between you, the other party, and the arbitration institutions. So that is the importance of arbitration institutions.
Okay. So one more question in chat box by Devesh Gade. How is the arbitrator selected in ad hoc arbitration?
It can be selected by both parties, number one. Number two, it can be appointed by the court as well. Like two parties, if they come into an agreement, they may write it in their agreement that so and so person is going to be the arbitrator if any dispute arises. If any dispute arises, that person becomes the arbitrator. If there is no arbitrator in the arbitration agreement or in the memorandum of understanding or any agreement, then one party may propose the name of the arbitrator to the other party. Number three, if the parties are not getting agreed to it, they may file a petition, an arbitration petition before the respective high courts for the appointment of an arbitrator. This is the process of ad hoc arbitration, and sometimes it becomes very lengthy. Sometimes it becomes quite difficult for the parties to arrange an arbitration. So it becomes very common, especially in Delhi and Mumbai, where people are at least aware of the arbitration proceedings.
Sir, good evening, sir. This
Very
is
good
Sami
evening.
Patati.
Yes, sir, please.
Sir, the discovery process in arbitration will be restricted. So, how it will be means how arbitration will reach to the resolution in that cases?
Sorry, sir, I could not understand your question. Can you please
Yeah,
repeat?
discovery process in arbitration is very limited, right?
Which process?
Discovery process, discovery of means getting information and all other stuff. That will
Disco
be
Discovery process.
yeah.
Okay.
So how it will help as an arbitrator to reach the resolution in such cases? Because we might have incomplete information, or we don't have complete information or something, and based on that, if you want to reach certain resolution, how it will be, will not be a bias in that case.
If you do not have certain, I believe you are talking about the non-availability of evidence
Evidence or
in
information, yeah, yeah.
evidence or information. Information it comes in in the stage of evidence itself. Even if you go to the court and if you don't have the information, your case is not that strong. If you do not have the information, if you do not have the shred of evidence to defend yourself, you have a weak case, be it arbitration or be it any dispute resolution mechanism or even in courts. So I don't believe that we have to blame arbitration for that. For the discovery of evidence in any civil dispute, there is no particular police agency which is going to investigate and dig out the evidence
Yeah,
or
but
information.
yeah, but the same process means police and everything will be there in case of arbitration also, or how it is?
Sorry?
The police investigation and all other stuff will
No,
be there.
no,
It
it's
will not
not.
be there, right?
It's completely a civil
Okay,
dispute resolution.
okay, okay.
Right. Thank you.
Thank you.
Sir, there is one more question by Anjali Gupta. What if a person is not satisfied with the arbitral award?
Then he may go to the, depending upon in which state he is. In UP, in Uttar Pradesh, we go to the commercial courts of that particular jurisdiction. In Delhi, we go to the High Court and we file an application for setting aside the award under Section 34. So 34, it's not written as appeal. It's not an appeal, but an objection to an award. So when an objection and for if I file an objection before the honorable court, the court may stay for a while. It may stay the order or the award from being executed. Similarly, if the award has to be executed, you have to file one execution petition before the court. So, in if the award is not getting, if the award is not being enforced, you have to approach the court. So that's why I said it's a myth that there are no involvement of courts in arbitration. There is a very important involvement of court in the arbitration process to make it a complete dispute resolution mechanism.
you, sir. Any more question?
Hello.
Yes,
Hello.
please.
Yeah, Raj here again, sir. Sir, in the absence of an investigative agency not being present, then doesn't that hamper the meting out of justice? And
It does.
also,
Mm.
yeah, and then also the law should follow the facts, right? And then if we can't um, find the facts, wouldn't that be detrimental to the whole system?
It does.
And then
I
how do
I
we safeguard against that?
I absolutely uh, agree with you, Raj. And for that respect,
So
we,
what are the measures in place, and can we hire private investigative agencies to do the
no,
job for us?
the private investigative agencies, then again, that evidence has to go through cross examinations. And
Hmm.
those cross examinations, I don't think so that any private investigative agencies would say yes to any cross examinations, because then it would again expose them and their mechanism, because certain information are confidential, like certain phone calls or phone records that you can't fetch from any other's phone. If you hire a private investigating authority and it does fetch it out, it leaves a very bad impression upon the particular party, and that evidence may not be admissible in the arbitration as well, because it affects the authenticity of that evidence. The
Okay.
arbitration is the arbitration tribunal is a
Hmm.
court which is not there to discover facts, but it has to arrive to a conclusion. And since these are
Okay.
the lacunas that we face in alternative dispute resolution, therefore, there are certain measures given in our Act as well as the other provisions that tackle with the setting aside of such awards. The awards which are not complete, the awards which are not based on proper discovery, the awards that are based on false and concocted facts, the awards that are based on loosely appreciated evidence. So the appreciation of evidence in arbitration is not as wide as the appreciation of evidence in Indian courts. So that's the major drawback, you may say,
Flaw.
in the arbitration process. Yeah. But again, it's an alternative dispute resolution. It's not the dispute resolution. So whenever you come to an alternative, you have to sacrifice something, some points.
Mhm. So then, is the approach different when these warring parties, these disputing parties, go to an arbitration tribunal? Is their approach different when they go to a court? So is it that they don't take it seriously enough,
No,
or
look,
how?
whenever you go to a court in civil dispute specifically, it's black or white. It's not gray.
Yeah.
It's not a criminal dispute that we have to see the intentions, we have to see the motive, and several other factors and their availability, presence, or absence from the spot. You
Mm-hmm.
go for a transaction, you go for an agreement. On the basis of that agreement, you go for a transaction, and that transaction has certain flaws. It reflects on your bank accounts, it reflects on various other books. So it does not have to do a lot with several other factors. It only has to check what is there on the paper.
Okay. Okay,
Yes.
sir.
So, yeah,
Thank you.
most welcome.
So there is one question by Pragya Zena. Is arbitrator decision is binded to the parties involved in the disputes as the traditional decisions taken by the courts?
As in, sorry.
Is arbitrator decision is binded to the parties involved in the disputes as the traditional decisions taken by the courts?
Yes, it is. It is enforceable, and if it is not enforced, then if it is not executed, then you may also file execution petition before the courts as well, and the courts will ultimately treat it as a decree of that court, and then will execute it. So the arbitral award, if it is not challenged, if it is not objected otherwise, it is always treated as a decree of a court. So it is having an equal value. So of course it is enforceable. Any other question?
I don't think so, sir. Any questions? Because the lecture was very much self-explanatory, I think so.
I really hope it was.
Yeah, sure, sir. It was. Uh, so I would like to move on to the closing session.
Please, sir.
Yeah, Ansh, Priyanshi.
Yes. प्रस्तावनायते साध्वे यत्र ज्ञानं समागतं स्मृतिषु सदा तेषां धर्मसंवादरूपिणी. This means the noble Prastavna, where knowledge has gathered, may its memory ever remain with us, in this form of dialogue rooted in Dharma. Really, sir, thank you for this enlightening session. It was indeed a fruitful session for learning. Over the course of this session, we have explored the nuances of arbitration, not just as a mechanism of dispute resolution, but as a philosophy of harmony, one that transforms conflict into dialogue and discord into balance. Today reminded us that law, at its best, is not about battles, but about bridges. It's not about winning against the other, but about finding a solution that stands for fairness and mutual respect.
At this juncture, it is a privilege to extend heartfelt gratitude. We are deeply thankful to our Dean and Principal, Dr. Ujjwala Bindale ma'am, our Vice Principal, Dr. Jyoti Dharam ma'am, our IQAC coordinator, Dr. Vidya Dhere ma'am, for their unwavering encouragement and constant guidance. Our sincere appreciations also goes to our respected professors, Advocate Rohit Survase sir, Mr. Shubham Tripathi sir, for steering this program with such dedication. A very special note of thanks to our chief guest, Advocate Shaurya Krishna sir, who graced us with his presence and shared invaluable insights drawn from his experiences at the Supreme Court and NCLAT. His words have not only enlightened us, but also inspired us to embrace arbitration as a living, evolving practice of law that upholds justice with dignity.
We would also like to recognize the tireless efforts of our organizing committee, the dedicated faculty, and of course, each of you participants who joined us virtually today. Your enthusiasm, curiosity, and active engagement have made this session vibrant and meaningful. Even though we were not connected through, even though we were connected through screens, the spirit of learning and collaboration was palpable throughout. This truly shows us that when knowledge is shared with sincerity, distance becomes irrelevant.
So
As we close,
I would just like all the participants to please on your camera so that we can have a group photo. All the participants, please can you on your cameras? Ansh, can you take screenshots?
so there is a glitch over here.
Yeah,
You have to perform it on the either side.
yeah, I will take it.
Sure, sir.
Okay, done. You can continue.
So, as we close today's session, let us remember the essence of Saamanjasya, the spirit of balance, fairness, and dialogue. May the lessons we have gathered today not remain confined to theory, but guide us in our studies, our practice of law, and the way we handle conflicts in everyday life. Let us carry forward the idea that true justice is not about power, but about peace, not about silencing, but about listening, and not about division, but about harmony.
At the end, I would just like to say Antasthi Prarambha. With that thought, we bring today's session to a close. Thank you all once again for your presence and participation. We look forward to meeting you in tomorrow's session with the same enthusiasm and spirit of learning. Until then, stay safe, stay inspired, and have a wonderful evening ahead. Thank you.
Thank you again, everyone. Thank you
Bye.
so
Have a
much.
good
Thank you,
day.
sir. I would
Thank you
like
so
to
much, sir.
also
Thank
thank our
Thank
student
you, sir.
coordinators, Ansh and Priyanshi, for a great work. And thank you, Shaurya sir, for accepting our invite.
Yes. Most welcome, sir. All the very best.
Thank you, sir.
All
Thank
the
you
very
very
best for the program.
Thank you, sir.
Okay,
Thank you.
okay, okay, sir. Thank you so much, sir.
Thank you.
Namaskar.
Thank you very much. Thank you, sir.